Hello and welcome to the Post-Grant Patent webinar. My name is Max Kralquist and I will be in the background answering any Adobe Connect technical questions. If you experience technical difficulties within the Adobe Connect session, please use the Q&A box on the right-hand side of your screen and our technical assistance team will help in any way possible. If you are having issues hearing over the phone, you may press *0 and an operator will assist you. Please note that as an attendee, you are part of a larger audience. However, to maintain privacy, the number and names of attendees will not be displayed. All attendees will be in the listen-only mode throughout the presentation, and as a reminder, today's call is being recorded. Q&A split screen. We will be holding a Q&A session at the conclusion of today's presentation. To submit a question, click on the Q&A panel located on the lower right side of your screen. Type your question into the text field and hit send. Please keep the send to default as all panels. This seminar is accredited for 1.0 hours of Illinois MCLE credit. Please inquire if you wish to seek CLE accreditation in additional states. During the webinar, we will be providing 3 CLE codes. Please write these down. We will be mailing evaluation forms at the end of the webinar and will ask for the codes. If you have any questions regarding CLE, please contact cle@brinksgilson.com. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce you to our first presenter for today, Peter Lee. Peter, you now have the floor.
Thanks, Max. Before I get started here, I will provide the first CLE code, number 1. It is February 25th. So in my first part of this webinar, I wanted to lay the groundwork for introducing the ethical duties in post-grant proceedings. You'll find that Rule 42.11 offers a duty of candor, which states parties and individuals involved in the proceeding have a duty of candor and good faith to the office during the course of a proceeding. Now, the office has stated that the duty of candor in post-grant proceedings was included because honesty before the office is essential to the integrity of the proceeding. And we know that the board may impose sanctions for failures to comply with this rule based on Rule 42.12, which I'll talk about in more detail in later slides, which deals with sanctions. Now, how do we interpret this duty of candor for the PTAB? Although similar to the duty of candor under Rule 56 for prosecution, the office has stated specifically that proceedings, not being applications for patents, are not subject to Rule 56. And as you may know, Rule 56 deals with the duty of candor and good faith during prosecution, and this includes the duty to disclose information material to patentability. Rather, the office's guidance provides that the scope of the duty under Rule 42.11 is comparable to the obligations under the tribunal imposed by Rule 11. So Rule 42.11 appears to require Rule 11 level of candor obligation when asserting facts and filings during a post-grant proceeding. This is further supported by some new proposed rules that propose changes to Rule 42.11, where the office has proposed to amend Rule 42.11 to expressly include a Rule 11 type of certification for all papers filed with the board with a provision for sanctions for noncompliance. Now, there is a question of whether this amendment increases the potential for sanctions for meritless filings in view of the present 42.12 sanction rules. But one could argue that the current sanction rules, in view of Rule 42.11 as it stands today, already requires a type of Rule 11 obligation even today. So let's move on to routine discovery in post-grant proceedings. I wanted to highlight routine discovery under Rule 42.51 B1.3. Unless previously served, a party must serve relevant information that is inconsistent with the position advanced by the party during the proceeding, concurrent with the filing of the documents or things that contain the inconsistency. The policy reason behind this discovery obligation is to avoid requests for additional discovery and to overall ensure a just, speedy, and inexpensive resolution. And now, this applies to both petitioner and patent owner, and is part of routine discovery obligation, such that inconsistent statements must be served with the filing of documents that contain the inconsistency.
Can I interrupt here, Peter, to make a remark on this?
Sure.
Right now, under the broadest reasonable interpretation standard for claim construction, you arguably don't, a party arguably does not have to inform the PTO that it's taken a different position with respect to a claim term in the district court than it has in front of the PTAB. But if the Supreme Court reverses the Federal Circuit in Quozo and requires a Phillips-type construction, then I think parties are going to have to consider whether or not they need to take consistent positions, or if they're not, they better A, disclose the inconsistent position and explain it. Sorry for the interruption.
No worries. Good point. So I've kind of described what the duty requires. Well, what doesn't the duty require? The duty does not extend beyond information that is inconsistent with relation to a position advanced by the party during the post-grant proceedings. It does not extend to privileged information, and the board has identified attorney-client or even attorney work product privileges. It does not require the party serving the inconsistent information to further specify the relevance of the inconsistent information. And also, the duty only requires that inconsistent information be served on the other party and not necessarily filed with the office or the PTAB. Now, I just wanted to, these are examples that the office has provided specifically for this discovery obligation. Example 1 goes to a petitioner, where a petitioner relies upon an expert affidavit alleging that a method described in a patent cannot be carried out. The petitioner would be required to provide any non-privileged work undertaken by or on behalf of the petitioner that is inconsistent with the conditions in the contentions in the expert's affidavit. The office also provides example 2 that applies to a patent owner, where a patent owner relies upon surprising and unexpected results to rebut an allegation of obviousness. The patent owner should provide the petitioner with non-privileged evidence that is inconsistent with the contentions of unexpected properties.
So, Peter, the implication here in discussing the routine discovery is that if a party does not comply with their duty to disclose inconsistent statements, they could be opening themselves up to allegations that they have not complied with duty of candor under Rule 42.11.
That is correct. However,
the other thing to consider here, pardon me for interrupting,
sure,
is that about 80%, I think the statistics thrown around by the PTAB is that 80% of these inter-party reviews and covered business methods reviews involve patents that are already in collateral litigation. So if you're going to take if you're taking a position that's inconsistent with something either in that litigation or in other litigation, you're running a risk that the other side is going to jump on it, and that will really affect your credibility in the proceedings before the office.
Good point. I think just really quickly going back to Rick's question here, the board has actually been pretty reluctant to authorize any kind of motions to compel routine discovery under this rule for documents that could include inconsistent statements. So what this means is that the mere speculation that the other party might be in possession of certain documents that might include inconsistent statements is not enough. Typically, I found that if a party files a motion for routine discovery and the other side represents to the board that it does not know of any inconsistent information, the board will take them at their word unless the moving party can point out something specific that triggered this obligation. However, there has been cases where the board has granted the motion to compel routine discovery when it has found that the motion specifically identifies the position that the party is filing, identifies information that is inconsistent to that position, and also shows that the party was aware of the inconsistent information at the time of filing. So it's possible, but hasn't been granted in a lot of cases. If you look at the slide that I have right now, this is, we talked about sanctions, and this is just Rule 42.12 Part A that identifies some exemplary conditions where the board may impose sanctions against a party for misconduct. And I'm not going to go through each of the examples, but I did want to highlight 1, 2, and 3, where if you kind of look at that in combination, this is kind of where I was talking about it would almost seem like the Rule 11 obligations are baked into the current sanction rule. And again, Rule 12, 42.12 Part B identifies some exemplary sanctions that the board may impose. One thing that I did want to note is that the office has stated that the board may sanction a party even after final written decision. And I note this because you would think that the board's authority may end with the final written decision, but the office has specifically said that the board has the right to sanction after their final written decision. This might come into play, for example, where the board submits a party's violation to the Office of Enrollment and Discipline after the final written decision for further disciplinary action.
It can also come into play, though, Peter, where evidence of an inconsistent position is discovered during parallel litigation, and that is brought to the board even after the final written decision.
Right.
So I think you have to keep them. I think parties have to keep in mind that they're basically litigating in two forms, and there can be, even though discovery is limited, very limited in PTAB proceedings, it's not limited at all, really, in district court or ITC proceedings. So it's another reason for parties to be extra careful, and even, especially the patent owner, try to be squeaky clean in PTAB proceedings.
That's right. That's right. So the next couple of slides, I just want to highlight some comparisons between the duties in post-grant proceedings under 42.11 and the Rule 56 duties that we're all aware of during prosecution. So Rule 56 applies to each individual associated with the filing and prosecution of a patent application, whereas Rule 42.51, B13, extends to inventors, corporate officers, and persons involved in the preparation of a filing of documents or things. Some have argued that the Rule 42.51 might have a greater reach as it expressly describes being extended to corporate officers. Going on to the discovery rules, discovery under Rule 42.51 only applies to information that is inconsistent with the position advanced by a party rather than information that is material to patentability as required by Rule 56. So it may be argued that Rule 42.51 is more narrow than Rule 56, at least with respect to the subject matter scope of the obligation. Finally, Rule 42.51, routine discovery obligations, would only require service of information that is inconsistent with the position advanced by a party to the opposing party, rather than actually filing the information that is material to patentability with the office as required by Rule 56. So Rule 42.51 would be arguably less burdensome than Rule 56 because it doesn't actually require the filing of information with the office. So what do we do? How do parties in post-grant proceedings ensure that they're abiding by their duties under both 42.11 and the routine discovery obligation? And the next part of this presentation, we're going to talk about and provide some scenarios where we bring up ethical duties for a petitioner at different points during the proceedings, as well as for the patent owner at different points in the proceedings.
Before we leave this issue, we've been talking generally about Rule 11, Federal Rule 11 in civil litigation, as opposed to 42.11 in PTAB proceedings. The application of Federal Rule 11 in civil litigation is a bit different because of the nature of, especially when you're looking at the initial complaint. A complaint in a patent infringement case is a notice pleading. so you don't have to lay out your entire case. A petition in an inter-party review or a covered business method review is actually the petitioner's case in chief. So you've got to lay out your whole case, and so as opposed to a complaint that only pleads in general terms, you've got to lay out your obviousness case or anticipation case, chapter and verse. And so it's got to be very factually precise, and I think that these Rule 11, parts of Rule 11 that we talk about in civil litigation about filing meritless lawsuits are less of a problem in the PTAB because you're actually putting up your case in chief.
That's right. So moving on to the part 2. Before I move on, I would like to identify the CLE code number 2, patent owner. And I'm going to hand it off to Eric Cohen, who will be moderating the second portion of this webinar.
Thank you, Peter. So if we turn to slide 21, to illustrate some of the issues that we've been talking about, we've decided to talk about some hypothetical scenarios, and we're just going to have a discussion instead of me just talking. So one of the things that happen in litigation is you can get barraged by, if you're a patent owner and you file a lawsuit and you're in any one of these districts that have local patent rules, which almost all of them do now, there comes a time when the defendants, and if you've sued more than one defendant, have to file invalidity contentions. And the rule generally is if it's not in your invalidity contention, you don't get to raise the invalidity issue at trial. So as a result of this, every conceivable combination that defendants are aware of are put into invalidity contentions, and often they can be quite long and very, they can run hundreds of pages. So if you are, you can be exposed to a lot of prior art that wasn't for the patent office and the prosecution of the patent. Another way this can occur is if you have a patent that you prosecuted in the U.S. and it's being prosecuted all over the world, after the patent issues, other prior art can come up in these foreign proceedings. And often, with these foreign proceedings have different standards for invention, so what might be relevant, say, in China might not be relevant here. So what happens, scenario number 1, after a patent's issued, but before filing the complaint, the patent owner learns of new prior art. So now we're talking about before you file the complaint, you're not getting invalidity contention. But what, for example, if you're writing cease and desist letters, or if you're trying to enforce a patent like some patent assertion entities are doing, you might get back in the context of your attempts to license, you might get back a lot of prior art being provided by the target licensee who says, I don't need to license this patent because it's invalid. So discovering prior art can arise in a lot of different ways. You haven't filed the lawsuit yet. You've got this prior art. So what can you do? If it's prior art that's been sent to you after the patent issued, there's no issue about having an obligation to erase it during prosecution because you didn't have it. But what can you do in terms of having this prior art considered by the patent office before you file a lawsuit? And one of the things you can do is supplemental examination under Section 257, which is new. It's a new part of the American Invents Act. And there's another thing you could do, and I think, Peter, you've raised this earlier, and that's reissue. So you could do supplemental examination or reissue. But since supplemental examination is new, let's take a look at it. Let's go to the next slide. So, section. Okay, I will try to talk louder. We have a central speaker here, and the three of us are probably a bit too far. So, I'll use my courtroom voice. Section 257 says that a patent owner may request supplemental examination to consider, reconsider, or correct information believed to be relevant to the patent. What is information? Well, it's a lot broader than patents or printed publications that you can get re-examined. Information is basically anything, and it could be, for example, if you have a concern about whether or not the claims meet patent eligible subject matter under Section 101. If you have a concern that somebody might argue that the invention was on sale, you can present that information to the patent office, and the regulations, which are Rule 16.01, and et cetera, tell you what you have to file. I'm not going to go through that. It's really beyond the scope of this. But you can present this, and let's go to the next slide. And the Patent Office, within 3 months, has to determine whether the information that you presented raises a substantial new question of patentability. If it doesn't, you have just given the Patent Office all this information. The Patent Office has said, well, it doesn't present a substantial new question of patentability, and basically that's the end of it. You get a certificate from the Patent Office saying that you've submitted this information and it does not present a substantial new question of patentability. If it does, you go into a re-examination proceeding, which is not limited to patents or publications, as we just described, and so you will get an examination based on this other information, a re-examination based on this other information. So, and so what are the consequences of this? Let's go to the next slide. Suppose some of this information is information let's suppose some of this information is information that you had before you filed the patent application or found out about during, in other words, your client had this information while the patent application was being prosecuted. If you delay filing the lawsuit until after either you get a certificate saying that the information does not raise a substantial new question of patentability, or after the re-examination is ended, then you basically insulated yourself from inequitable conduct unless there's been an out-and-out fraud. For example, let's suppose that your client knew about this information and intentionally didn't give it to the Patent Office because it wanted to get the patent. Let's say there was a fraudulent intent to deceive. It doesn't insulate against a knowing fraud, but it does insulate against inequitable conduct based on an inadvertent disclosure. The other thing is the exceptions to this. So you get this insulation if you wait until after the re-examination is done. You also have to file this request for supplemental examination before somebody raises an issue of inequitable conduct. So, for example, inequitable conduct could be raised in a notice letter submitted under the Hatch-Waxman Act. So you wouldn't get the insulation from inequitable conduct if you filed the request for supplemental examination after you got the notice letter. But the inequitable conduct, it has to be set forth in the notice letter with particularity, so it can't just be just a general statement of inequitable conduct. So it's a pretty interesting way for patent owners to get this additional prior art before the office. The question is, has this really been used so far?
Not a lot. The Patent Office provides statistics on this, and for fiscal year 2015, there were 52 requests for supplemental examination. So it hasn't been used a lot. I think the Patent Office believed that before the AIA was enacted, they believed that it would replace ex parte re-exam. Excuse me. But it hasn't caught a hold yet with patent owners. There's still patent owners filing ex parte re-exams. Interesting statistic of the so as Eric mentioned, if you file a request for a supplemental examination, it could lead to the Patent Office instituting a re-exam if they find that the art you've raised or the information you've raised raises a substantial question of patentability. In 2015, of the decisions the Patent Office made on whether a request for supplemental examination did indeed raise a substantial question of patentability, about just under 70% of the time they said that it did and instituted re-exam. So it's more likely than not that if you file a request for supplemental examination, it will lead to a re-exam. Given that high percentage, that begs the question, why not just file the re-exam? But there are some advantages to going, even if you're going to end up in re-exam either way, there are some advantages to getting there using the supplemental examination route. And the big one is when a patent owner files a request for re-examination, they have to affirmatively argue that what they're raising raises a substantial question of patentability. They have to argue that. And that can be an uncomfortable position for patent owners to be in, to make those arguments with respect to their patent. If they file a request for supplemental examination, they don't have to argue that what they're raising raises a substantial question of patentability. And then if they end up in re-exam, they've gotten there without them having to start the process making those arguments against their own patent. And then they can just, if a re-exam is instituted through supplemental examination, they can just, their first substantive arguments in that proceeding are in favor of patentability, not that the art raises a substantial question of patentability. So there are benefits, even if you end up in re-exam either way, there are benefits to using supplemental examination as the mechanism to get this information before the Patent Office.
And this is actually, so to Rick's point, what you're required to do in the request for supplemental examination is to identify each claim of the patent for which supplemental examination is requested and give a detailed explanation of the relevance and manner of applying each item of information that you're submitting for the supplemental examination. So it's short of saying that you don't have to say it raises a substantial question of patentability. It's for the Patent Office to determine that. Now, apart from using this to basically take away the defense of inequitable conduct with respect to information that your client may have known about, that your client had in its possession, but it just never got to the patent attorney who was prosecuting the case. This may be, although it's a very expensive way to do it, this may be a way to deal with prior art that gets cited by licensees or prior art that's cited in litigation if you're really concerned about it, because it gives the patent owner an opportunity to have that determined by the Patent Office. But it can slow down. I mean, it can greatly slow down any litigation that you want to file. So let's move on. Let's find out what happens if you play fast and loose with the patent office. How is that going to come? How might that come back to bite you? So we have the case of Novartis versus WebVention Holdings. This is a fairly recent decision by the District of Maryland. So WebVention is a patent assertion entity, and it initiated a broad enforcement campaign demanding license fees in the range of $80,000. It paid within 45 days and suing companies that didn't pay. So this is your typical nuisance value settlement. And the court found the company's sole purpose was to exploit the high cost to defend complex litigation to extract the nuisance value settlement. You can already see where this is going. So Novartis gets a cease and desist letter or one of these dunning letters from WebVention and decides to file a DJ action. And this was consolidated with a bunch of other cases by the MDL panel. Somebody else filed re-examination proceedings against the WebVention patent. So the re-exam proceeds. It doesn't include prior art that an accused infringer had sent to WebVention's counsel. WebVention gets a certificate from of finding all the claims are patentable, and then after it gets the notice that it's going to get the certificate, and after the deadline for filing an IDS, it finally submits this other prior art that it had known about. You can go to the next slide. So somebody else files a new re-exam, filing the previously withheld prior art. It results in final rejection of all the claims. So Novartis basically sends a letter to WebVention and says, and proposes dismiss the case with prejudice. Admit the patent's invalid, dismiss it with prejudice. WebVention refuses to stipulate the claims are invalid, and it refuses to stipulate that Novartis didn't infringe. So Novartis moves for judgment, and it files a motion for attorney's fees. So in the meantime, WebVention winds up at the fairs. What a surprise! And now it's arguing that the winding up of its affairs avoids liability for fees, and the court, of course, says there's no law anymore supporting that proposition. And so the court finds that overall, WebVention's conduct, beginning when it first acquired the patent, began demanding license fees at a cost intended to induce settlements, to its withholding of information in front of the PTO, to its conduct in relation to Novartis, justifying inference of improper motives, litigation misconduct, subjective bad faith, and counsel in favor of awarding attorney's fees to deter this kind of litigation behavior. Now remember, under the Octane case, a court can find that a case is exceptional based solely on litigation misconduct. And here the court's finding litigation misconduct, including WebVention's conduct before the patent office. So you have an award of fees and a lawsuit based in part on misconduct in front of the patent office. And so that is how this can come back and bite a patent owner if the patent owner is trying to play fast and loose. So now let's get to our second hypothetical. So the patent owner, the petition for inter-party review is filed, and before the proceeding is instituted, the patent owner learns of new prior art that it hasn't been identified. So what is the patent owner's obligation here? So Peter, is there any rule that permits the filing of an IDS in a PTAB proceeding?
No, the office has actually they've been pretty clear, as well as the board, that there isn't a mechanism within a post-grant proceedings to file information like this, such as an IDS. And I think it all goes back to the board and office, I guess the office, stating that this isn't prosecution, this is a proceedings. And so, they don't have any kind of mechanism that would make it easy for them to file any type of information.
Now, so does the patent owner have any obligation at this point to say anything?
I don't think so. I think that at this point, particularly when the patent owner is preparing their preliminary response, the scope of their response is dictated by the petition. So they are responding to what the petitioner has raised. There's no duty to respond to or make available information that isn't responsive to what the petitioner raised in their petition. So at this stage of the proceeding, it doesn't seem that there's any duty for the patent owner to disclose, in this hypothetical, a piece of prior art.
Okay, so let's think about what of course, the patent owner can file a preliminary response. And in that preliminary response, the patent owner can try to make a case that the petition does not raise a likelihood that any of the claims are unpatentable. And so the patent owner's preliminary response is basically attacking the specific prior art that the petitioner relied on in filing the petition. So if the patent owner is arguing basically if the patent owner is saying that prior art A doesn't disclose this and prior art B doesn't disclose that, it would seem that under that circumstance, there would be no need at that point to raise this additional prior art. The question becomes, though, whether, let's say you're arguing that prior art A doesn't disclose something, and prior art B doesn't disclose something, and so basically you're saying there's a missing element. What if that missing element is supplied by prior art C? Is your knowledge of prior art C that provides a missing element that's not in A and B, is that inconsistent information? Is that something you would have to disclose as part of routine discovery? I mean, I haven't seen a case on that.
So I think that's the question. That's the interesting question because, as Rick mentioned, on its face, the patent owner's responsibility is to respond to the petition. And as long as they are responding to the petition and they don't stray too far from that, they likely won't invoke any type of routine discovery rules in light of the inconsistent statement.
Another scenario where this may come up is in their preliminary response, the patent owner isn't arguing reference A doesn't disclose X, but they're arguing in response to an obviousness contention that there's no motivation in the prior art to combine these two references. But what if the patent owner is aware of a reference that may go against that?
That provides the motivation.
That provides the motivation.
But if you're arguing that there's no motivation in the references cited by the petitioner, then, I mean, there might be motivation in other prior art that the petitioner may or may not know about. You're basically attacking the pleading. This is almost in the nature of, it's sort of analogous to a motion to dismiss, because you're basically saying that this pleading that they filed, this petition, fails to meet the standard for institution of the trial. And that's really what you're arguing. So, but I think this is something you need to keep in mind. So why don't we go to the next slide? This is our, and this probably is the more difficult hypothetical, because now the proceeding's been instituted, and so suppose the patent owner has decided to file a motion to amend. And now the patent owner is aware of prior art that hasn't been considered, hasn't been identified during the proceedings by the petitioner. So let's take this in two parts. Let's suppose you're in litigation, and you're in litigation. The petitioner filed this petition because the patent owner sued the petitioner. And let's suppose that the patent owner requested and was given during discovery in the underlying lawsuit, either before or after the petition was filed, all the foreign prosecution files, and that those foreign prosecution files include prior art that obviously hasn't been cited by either the petitioner or wasn't considered by the Patent Office in the prosecution of the patent. You file a motion for leave to amend, and you file your amended claim. Do you have to disclose to the PTAB information that the petitioner already has because he got it during discovery?
It's a little bit of an open question still, but there's some relevant decisions by the Patent Office that bear on this. The first one is the idle-free decision, which is not cited in our slides. The site for that is IPR 2012-00027, paper 26. And then the master image decision that's mentioned in our slide provides more clarification on idle-free. But what idle-free says is that in a motion to amend, the burden is not on the petitioner to show, this is for the proposed amended claim, the burden is not on the petitioner to show unpatentability, but on the patent owner to show a patentable distinction over the prior art of record and also prior art known to the patent owner. So what does that mean? What does the master image decision provided more elaborated on what that means? In master image, prior art of record is material in the prosecution history of the patent, material of record in the current proceeding, which would be, in this hypothetical, the inter-parties review proceeding, material art of record in any other proceeding before the office involving the patent. That's pretty straightforward. But as I read in the idle-free decision, there were two categories of documents or prior art. That which is of record and that which is not of record but known to the patent owner. In the master image decision, the board explained what quote-unquote prior art known to the patent owner means. They said it should be understood as no more than the material prior art that patent owner makes of record in the current proceeding pursuant to its duty of candor and good faith to the office under Rule 4211 in light of a motion to amend. So this, in providing this explanation, the board talks about art that's been made of record by the patent owner that's material to the patentability. It's material to their proposed amending claims.
So this basically says, is the way I'm reading master image, this basically says that you've got, if the patent owner thinks that the prior art, the new prior art is material, you've got to make it of record in the IPR when you file your motion to amend, when you file your proposed amended claim, your motion to amend the claim. And that can be done as exhibits to the motion, but the safe thing to do there is to make it of record. Because, and that's a way, even though there's no provision for an IDS, if you're filing a motion to amend, then you do make this a record. Now, this is not on any slide, but now let's say you decide I'm not going to amend. Why should I file a motion to amend? I mean, they're never going to grant it. You know, my chances of getting the PTAB to grant a motion to amend are about the same as my chances of winning the Illinois lottery. So, so now what do? You've got this prior art, and let's say it's arguably even better than the prior art that's been cited by the petitioner. And so that now the question becomes, you know, like, what do you do? Well, the safest thing to do, I think, is to disclose it to the petitioner. There's no real way to make it of record there's no formal way to make it of record, but you could, let's say you file your patent owner response. You file your patent owner response, nothing prevents you from filing a declaration saying, we're aware of all this other prior art and we gave it to the petitioner. So you could at least make it a record that way. The problem is that because of the one-year deadline for completing an IPR proceeding or a CBM proceeding, there's no way really that this new prior art is actually going to be considered by the PTAB during the proceeding. And that was one of the cases that we cited earlier.
Right. I was just going to mention that in the previous slide, the PCT International case, it was a case where the patent owner became aware.
Go back?
Yeah. The site on this slide, the patent owner became aware of art cited in a foreign case, a corresponding European application. They sent it to the petitioner, and then they asked the board, hey, what else do we need to do to comply with our duty of candor? And the board basically said they didn't go out and say you've met your duty, but they said there's really no mechanism to bring this into the case at this point. And so that's just assigned to patent owners. You know, they played the safe route, like Eric said, gave it to the petitioner, but beyond that, there's not a lot else they can do with the prior art they may become aware of.
You can't do it in this proceeding, but you can, at this point, you could file a Section 257 request for supplemental examination if you're concerned about it. And so that at least gets it in front of the patent office so that, and, you know, depending on, you know, it may slow, if you're in litigation, it may slow down the litigation, but at the end of the day, it may protect you from arguments that, well, you survived inter-party review, but look at all this other prior art that wasn't considered. I think this depends in part, your strategy for dealing with this, let's go back to the third hypothetical. I think your strategy for doing this depends on where the prior art came from. If the prior art came from, because now you're in the inter-party review proceeding, and the underlying lawsuit may or may not have been stayed before the defendants had to provide their invalidity contention. So if this prior art came via invalidity contention, maybe you just want to say, look, they were the ones that chose the prior art to put in their petition. They chose obviously what they thought was the best prior art, and it's not our job to tell them how to practice law. They obviously didn't think it was as good as the prior art that they chose. I think some of this depends on timing of when the information is disclosed. So if the patent owner has decided not to file an amendment, there are ways to get this information at least in the record. and that way no one can accuse the patent owner of having failed to disclose something. But again, I think it depends on where the prior art came from. I wouldn't see a need to cite it if the prior art came from the invalidity contentions that you got in the lawsuit, because then you've got an argument that, look, they're in a joint defense group. They obviously knew about this. Everybody knows about everything, and they chose not to use it. And so I think you're probably fine. So
might be worth just discussing briefly the Nike case, that federal cert case that just came out this month. It relates to the motion to amend and duty to candor. In Nike, as I mentioned, reading the master image and idle-free decisions, there's two different categories of prior art you're supposed to that should be addressed somehow: the prior art of record and prior art not of record but known to the patent owner. That second category is what was at issue in Nike. In the patent owner's motion to amend, I'm going to read what they said regarding prior art not of record but known to the patent owner. They said, proposed claims are patentable over the prior art, including prior art identified by the board in its decision on whether to institute a trial, and other prior art known to Nike. So that's all they said. It was patentable over other prior art known to the patent owner. The board originally denied the motion to amend in part because they said this statement was not enough to comply with the requirement to discuss patentability over art not of record but known to the patent owner. The patent owner, Nike, appealed on this point, and the Federal Circuit remanded. They agreed with Nike. They said, and they tied it to the duty of candor. What the board said is that at the heart of idle-free, as interpreted by master image, is the question of whether the patent owner has submitted the necessary information to comply with his duty of candor to the office. In this case, there is not, and there has never been an allegation that Nike violated its duty of candor. So, and then they said after master image's explanation of idle-free, we cannot see how the statement used by Nike would be inadequate absent an allegation of conduct violating the duty of candor. So Nike's, the patent owner's blanket brief statement was enough to comply with the requirements set forth in master image and idle-free, and it would have been upon the petitioner if they felt like Nike was, or the patent owner was, hiding something to bring it up, but they didn't.
So implicit in the Nike decision is the fact that the patent owner has an obligation to disclose prior art with the motion to amend, so long as that prior art is material. And if the patent owner does that, then the patent owner can simply say, can simply make the broad statement that Nike made, and that's sufficient. So the question becomes, like, how much prior, so the obligation is to disclose, let's think about this, you have to disclose prior art that's material. So you've got a lot of prior art. Now some of it may be so far out there that you realize that there's no way anybody in the right mind would think it would be material. On the other hand, you know, it's hard to sometimes anticipate what type of argument somebody might make if they have the prior art and really think about it. So the question is, where do you draw this line? Because the obligation to disclose in connection with the motion to amend is only that prior art which is material, but are you better off just saying we think this prior art is material, and listing it, and then saying in connection with the filing of the motion, and here's other prior art that we're aware of, but we don't think it's material. In other words, are you better off disclosing all of it to avoid somebody down the line saying, wait a minute, you didn't disclose X, Y, and Z, and because the obligation exists, even if the prior art only supplies one of the elements of claim. So that's something I think to keep in mind. And I think that could be done even as maybe as a list that you submit. At least that way, look, the petitioner's on notice. If the petitioner thinks that it's material, the petitioner can raise it in response to the motion for leave to amend. So giving it, disclosing it, giving it to the petitioner, I think is probably the best way to make sure that you're complying in the 2020 light of hindsight with your obligation under Rule 4211.
I think that's right. So yeah, the rules, ethical rules, 4211. I think we have to consider them when we are filing motions. When the patent owner files a motion to amend, it does bring into all these questions that we've talked about. I don't know if we have time, but I know that there has been recent discussions about some changes to the law, talking about how to amend claims at the post-grant proceedings, specifically the off-ramp provisions. Eric, I don't know if you had some thoughts on the off-ramp provisions that have been proposed.
Well, actually, the patent office, not the patent office, the PTAB, in at least one decision has suggested that if you really want to do full amendments to the claims, you should either do it in a re-examination or reissue proceeding.
That's right. Yeah.
The reason for the off-ramp, and it hasn't even been proposed in legislation, it's something that's being considered by some Senate staffers, and
right.
It's an idea that's been floated. The reason for it is because, and I'm told this by some colleagues, that in at least one case, the patent office decided there was not a substantial new question of patentability sufficient to do the re-exam because the PTAB was already considering the same prior art in the PTAB proceeding, which is sort of opposite of what the PTAB said the examining division should be doing in considering these things. So it's available now. You can do it now. You can file a request for supplemental examination. You can file a request for a reissue, or something along those lines.
Right.
And PTAB has actually blessed this in a decision. So that's one way you can deal with it. But the problem I see with them, and this is another one of these problems with a motion to amend, filing a motion to amend can create this obligation to submit prior art. The obligation doesn't exist if you're just simply arguing against the positions that the petitioner is taking in the PTAB proceeding.
Yeah.
And so the question you have to ask yourself is, if the motion to amend is so greatly cabined in a PTAB proceeding, why file one at all? Why not try to do it through the request for supplemental examination or reissue?
Good point. And like you said, I think those vehicles are available currently, so something to consider for patent owners.
Do we have time for questions?
I think we're time. So I think we are coming up to our time limit here, and before we let you go, we need to give you the last CLE code, which is PTAB.
Thank you for attending today's post-grant patent webinar. CLE code number 1 is February 25th. CLE code number 2 is patent owner. CLE code number 3 is PTAB. Wonderful. And if you have any closing remarks, feel free to go ahead.
No, that's it. Thank you, everyone, for attending today's webinar. We appreciate your time and look forward to doing it again. Thank you.